Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, right after the big, beautiful bill was signed into law on July 4th of this year, it took no time for GOA to drop its lawsuit challenging certain provisions of the National Firearms Act. And today we have a new filing from the good folks over at the Firearms Policy Coalition doing relatively the same thing. There are some nuances, and I think the way they articulated the argument here is really, really good. So let's go through the complaint, let's figure out where they're coming from, and let's talk about what the likely outcome is. So today, let's spend a few minutes and let's talk about another major challenge to the NFA. Okay, America, we are talking about yet another challenge to the National Firearms Act. The case that we're actually talking about today is the matter of Jensen versus ATF, a newly filed complaint in the United States District Court for the Northern District of Texas. It is brought to us by our good friends over at the Firearms Policy Coalition, which means there is a link down below for you all to show them some love. Now, we'd already talked about GOA dropping a lawsuit just about the time the ink was dry on the big, beautiful bill, and this one follows a similar line of attack, but I think that again, with giving a little bit more time for this issue to percolate, if you would, FPC has done a really, really nice job of outlining what this issue is all about in a very straightforward, easy to understand format. Important to note, the challenge here is actually to the inclusion of suppressors and short barrel rifles in the NFA. So this is not an attack to the NFA in its entirety. It is an attack on suppressors and SBRs being under the purview of this federal regulatory scheme. Now, for those of you who don't really understand this issue other than the NFA is a bunch of BS, let me break it down to you this way. There are two types of firearms for purposes of discussion. There are firearms and there are NFA firearms. Now, anytime we are trying to accumulate and or possess these items, we are subject to certain federal restrictions. For example, for a regular firearm, we have to fill out a form 4473. We have to go through a background check, and for some of us, we have waiting periods. Beyond those restrictions, other than being a lawful and responsible gun-owning American, that is about all you are held accountable for. But if you have the audacity to want to go out and get an NFA firearm, well, instead of a 4473, you're going to fill out either a Form 4 or a Form 1. Yeah, you're going to go through a background check. Oh, you're also going to get fingerprinted, and there will be a waiting period because they got to process all these applications. Oh, the firearm will have to be registered with the federal government. Of course, there's all sorts of rules and laws related to the possession of these items. You got to have permission to travel with any of these items before you actually travel. And of course, a violation of any of these provisions subjects you to prison time, which is a whole lot more regulation on these firearms over here than these firearms over here. How is that even possible? Well, it goes back to two things. Number one is that when the National Firearms Act was challenged in 1937, just 3 years after it was enacted, there was a case that specifically held, no, this regulation has nothing to do with gun control whatsoever. It's all about taxation. FPC wisely points out in their complaint, the Supreme Court upheld the NFA's occupational tax on dealers against constitutional challenge in 1937, holding that the NFA was only a taxing measure and thus lawful pursuant to Congress's taxing power, and that the registration provisions were obviously supportable as in aid of a revenue purpose. Okay, so all these extra regulations over here have been justified not under the Second Amendment, but as part of Congress's taxing power. But here's the thing. We talk all the time about the Commerce Clause and how the feds basically get their hands on anything by claiming it all has to do with interstate commerce. FPC puts an interesting wrinkle in here when they point out that, hey, listen, when you guys included Form 1s, personally made NFA items, in the Gun Control Act of 1968, thus incorporating it into the NFA, well, tell me what a homemade firearm that's made exclusively in a state, possessed exclusively in a state, has anything to do with interstate commerce. And that leads the plaintiffs here to point out, in 1968, Congress expanded the scope of the NFA. Originally, the NFA only regulated the transfer of covered firearms. But in the National Firearm Act amendments of 1968, Congress also subjected persons who make their own covered firearms to the NFA's tax and regulatory scheme. Congress extended the NFA tax to activities that could be undertaken alone with no plausible relation to commerce of any kind, much less interstate commerce. So, with no taxation left anymore for suppressors and short barrel rifles, and the fact that Form 1 items that really have no reflection on interstate commerce whatsoever are still regulated, FPC is making an argument that, listen, not only is the NFA in portions unconstitutional in its current application, it's probably unconstitutional in its original formation. As the plaintiffs put it in their complaint, this regulatory regime no longer comports with Congress's constitutionally enumerated powers. While the NFA's regulations may have been permissible in support of the statute's taxes on making and transferring firearms, that justification no longer remains for items whose making and transfer are no longer taxed. To the extent that the NFA imposes requirements on making, transferring, receiving, possessing, or otherwise using untaxed firearms, it cannot be justified as an exercise of any Article 1 power. Accordingly, the NFA is unconstitutional as to the untaxed firearms. So, argument number 1, it exceeds Congress's authority. Argument number 2, it's in violation of the Second Amendment, or as FPC puts it, wholly apart from the NFA's constitutional infirmity in the above respect, the NFA's restrictions also constitute an unconstitutional regulatory scheme as it pertains to suppressors and short barrel rifles under the Second Amendment. Okay, so now, if you don't have any taxation reasons to have all of this extra regulation over here, we're going to have to analyze it under the plain old Bruin test, which number 1, we're going to ask, does the text of the Second Amendment actually cover this activity? And then number 2, are there historical analogs to justify the existence of all of these extra regulations over here? Now, when it comes to suppressors, we know that for whatever reason there is a debate as to whether or not suppressors actually constitute bearable arms. And FPC actually has to make that argument. Fortunately, they rely on the government being willing to stipulate to it, which may actually save several pages in this complaint. The government agrees that suppressors are protected by the Second Amendment. So if they are in fact arms, then they can only be regulated to this extent. What? If they were dangerous and unusual? Well, here's the thing. Suppressors are not dangerous. As a matter of fact, they make the use of firearms considerably less dangerous. And when you take a look at the number of suppressors that are in circulation, heck, you could probably just take a look at the number of suppressors that went into circulation in the last few months. It is impossible to say that they are unusual. They are very, very prevalent in mainstream American commerce. Then we get over to the short barrel rifles. Well, are they arms? I don't think there's any debating that. Are they dangerous and unusual? Well, all firearms are dangerous, but are they uniquely or unusually dangerous, I guess? Well, FPC points out, first, for dangerousness, there is nothing about a short barrel rifle that makes it more dangerous than other protected arms. Well, that is absolutely true, and the truth of the matter is that all bearable arms, especially firearms, are in fact dangerous, especially in the hands of idiots. Are they unusual, though? Well, FPC very correctly points out, second, regarding unusualness, short barrel rifles are in common use in the United States. As of May 2021, there were 532,725 short barrel rifles registered with the ATF. Is there any history to justify this regulation? Well, the historical analog's already been done. We're talking about regulation of platforms of firearms. Finding that they are not dangerous and unusual. In fact, that means they are what? That's right, in common use for lawful purposes, means that the history's already been done and the regulations cannot stand. Now, we know how much those that promote civilian disarmament will try to play and bastardize this test. What I appreciate here is FPC basically said, no, it's a very, very straightforward equation. It's really just this simple. Because suppressors and short barrel rifles are not dangerous and unusual weapons, they are protected by the Second Amendment. And there is no historical tradition that would support the NFA's all-encompassing registration scheme for suppressors, short barrel rifles, or any other protected arm. Okay, and then finally, that's right, remedies. You don't have a lawsuit if you don't have remedies. What is it that the Firearms Policy Coalition is asking the court to do? Declare that such requirements and any regulations implementing them violate the Second Amendment with respect to suppressors and short barrel rifles, both facially and as applied. Enjoin defendants and their employees, agents, successors, or any other persons acting in concert with them from implementing, enforcing, or otherwise acting under the authority of the NFA with respect to violations in any way predicated on failure to comply with the NFA's unconstitutional provisions pertaining to making, transferring, receiving, possessing, or using untaxed firearms, or in the alternative, untaxed suppressors and short barrel rifles against individual plaintiffs, Hot Shot Custom, and its customers, and the members of the organizational plaintiffs. Okay, and then in addition to the FFLs and the individual named plaintiffs, yes, the Firearms Policy Coalition brings this. Also, the Citizens Committee on the Right to Keep and Bear Arms is a named plaintiff, which I think then brings the Second Amendment Foundation into this whole thing and all of their members as well. We're going to carefully watch this case, as we will with all other challenges to the National Firearms Act. The case, once again, is Jensen versus ATF. We're going to link up the complaint down below, along with a link for you to show FPC some love so you can do all of that. Now, listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.